There's been a lot of drama with OpenAI lately, but one thing that's been overshadowed is the recent announcement of something called Copyright Shield. At OpenAI's Dev Day earlier this month, former and potentially future OpenAI CEO Sam Altman announced that OpenAI will step in to defend customers who are sued for copyright infringement in connection with their use of OpenAI products such as ChatGPT. So, what does this mean? And perhaps more importantly, to whom does this policy apply? The company's official blog post announcement stated, quote, OpenAI is committed to protecting our customers with built-in copyright safeguards in our systems. Today, we're going one step further and introducing Copyright Shield. We will now step in and defend our customers and pay the costs incurred if you face legal claims around copyright infringement. This applies to generally available features of ChatGPT Enterprise and our developer platform. That's the key phrase. Similarly, in his Dev Day keynote, Sam Altman said, quote, we're introducing Copyright Shield. Copyright Shield means that we will step in and defend our customers and pay the costs incurred if you face legal claims for copyright infringement. And this applies both to ChatGPT Enterprise and the API. Again, the key phrase. So first, what does this mean? OpenAI's Copyright Shield program sounds like it's really just another way of saying indemnification. Indemnification is actually a very common term in business contracts. When a company offers to indemnify you, it means that if you are sued and lose, they will pay the judgment for you. And depending on the specific terms of the indemnification provision, they may even pay for your lawyers to defend you throughout the process, because those costs can really add up. So those are common provisions in business-to-business contracts, but in consumer contracts, the indemnification provisions are often seen going in the other direction, meaning that they are the fine print provisions that a company puts in there that says, you promise to indemnify the company if they are sued because of you. So OpenAI's Copyright Shield is great in the sense that it protects the OpenAI Enterprise and API customers rather than the other way around. In doing so, OpenAI joins some established companies such as Amazon, Google, and Meta that offers some copyright indemnification to its enterprise customers, but many of the startups in the AI space still don't indemnify their customers, and that includes even some of the startups that have been sued for copyright infringement. Now, it's important to note that OpenAI's Copyright Shield applies only to copyright infringement claims. They're not promising to pay for anybody's legal defense for using ChatGPT to perpetrate a fraud or anything like that, for example. But the more important limitation is in who benefits from this new policy. Copyright Shield applies to enterprise and the API, meaning developer customers. So if you have an established enterprise business-to-business relationship with OpenAI, and you have a contract with them, it apparently will now include this Copyright Shield protection. And if that applies to you, you've probably had lawyers involved in reviewing those contracts, and you may not be trying to learn about this through a YouTube video. But for most OpenAI customers, meaning free users and even paid users of ChatGPT Plus, Copyright Shield does not apply to you. In fact, if you have a small business, the indemnification travels in the opposite direction, meaning you may have to indemnify OpenAI. Their current terms of service for consumer and non-enterprise business clients states, quote, if you are a business or organization, to the extent permitted by law, you will indemnify and hold harmless us, our affiliates, and our personnel from and against any claims, losses, liabilities, and expenses, including attorney's fees from third-party claims arising out of or relating to your use of the services and content or any violation of these terms of service. And the developer coverage for Copyright Shield applies to OpenAI's formal AI program, but not to custom GPTs. So I'm filming this video because I don't want you to see the headlines and just think, oh, great, ChatGPT, OpenAI, they're going to pay for my lawyers and now I can do whatever I want. If you as a consumer are training a new custom GPT using copyrighted materials that you don't own, that could still spell trouble. Now, typically, plaintiffs' lawyers who sue over stuff like this want to go after the deep pockets, meaning they're more likely to sue a big company than an ordinary consumer or a small business. However, in this case, there could be instances of larger companies potentially suing ordinary consumers to protect the large company's intellectual property rights. We don't know yet. It's an emerging area of law, and much is yet to be seen. But it does remind me of the old Napster days where you would see huge record companies banding together to sue some like college students who had illegally downloaded music to make an example of them and protect their intellectual property. Similar things could happen here, so be careful. It'll be interesting to see how it all develops, but I don't want you to assume that you as a consumer or small business are protected here, because that's not what Copyright Shield does. Okay, if you found this video offered you some value, please remember to click like, subscribe, and click the notification bell for more videos like this. Thanks for watching.